So now, if I receive the matter from you, and maybe tomorrow your opposite try to find another same matter in the arbitration. So how do you think about it? Hi everyone, my name is Stephen Lee, managing partner of Litigation law firm. Today we have the podcast session with the topic about the arbitration clause in the commercial contract. We have the Jeremy Markhon, our special counsel, who focus on the international dispute resolution, have with me today to discuss about some simple concept about the arbitration clause. Hi Jeremy.
Hi Stephen.
Yeah, we have the next podcast with you now, and
Indeed.
yeah,
We're back.
yeah. Okay, so today we talk about the arbitration clause in the agreement, commercial agreements.
Yep.
May you share some basic concept and experience with the arbitration clause?
Great. Happy to. Look, in an international commercial context, it's something that pretty much all contracts have. And if it's a topic that the audience is not familiar with, most international disputes get solved in an arbitration center. And how does that happen? Because of the arbitration clause. It all starts there, or agreement, etc. So that's where it all begins. Where is it located? It could be a clause in a contract, or it could be an addendum or an appendix that the parties have agreed together. So,
yes, in my experience at the litigation at court, I see that some commercial agreement, they also mention about the arbitration jurisdiction and the court jurisdiction. Is that acceptable in the international practice?
Well, jurisdiction is a concept which sort of can suck the oxygen out of the room, so to speak. It's simply put, jurisdiction is for the tribunal or court to hear the matter. And as a general proposition, the courts in the international realm, if there's an agreement to arbitrate, they will always, generally speaking, try to uphold that agreement. Why? Because it's an agreement between the parties to stay out of court. So courts try and honour that, to honour the arbitral tribunal jurisdiction.
In Vietnam, in my experience, cannot provide this at the same time the arbitration jurisdiction and the court jurisdiction in the same agreement. Even many colleagues try to argue with me, okay, but for the separate matter, we may identify the arbitration jurisdiction for some certain dispute, and for other certain dispute may provide the court jurisdiction in the agreement, because the client also afraid that some issue is be better settled by the arbitration and the other may be better settled by the court. I see that it cannot, because that when in reality I bring the agreement, we file the lawsuit, and in the agreement there is a conflict between the arbitration jurisdiction and the court jurisdiction. The judge will question exactly what jurisdiction the judge or the arbitration you want to follow to settle the dispute, because in the end all of the dispute you mentioned in the contract relating to the transaction you are doing, and because of you have the dispute, that's the reason why you refer to arbitration or the court. So now if I receive the matter from you, and maybe tomorrow your opposite try to find another same matter in the arbitration, so how do you think about it?
Look, that's an interesting topic. What you're saying is, in an arbitration agreement, you've got some matters, yes, we're going to arbitration, and the other matters we're going to go to court. Okay, what about other matters not specified? It's neither here nor there. What do we do then? It could be void for uncertainty. So there's a real risk that clause could be totally invalidated by a court. I think it's really risky. That sounds danger.
So, from your perspective, is it better to have the only one arbitration or the court jurisdiction in the agreement, right? Or
Definitely.
yeah,
Definitely. Make it clear and unambiguous. And, there's a huge push internationally to go into arbitration because there's so many benefits. You can choose where, the language, who arbitrates, all in the arbitration agreement. You can't do that with a court. Once you're in court, you're stuck with the system. So there's more flexibility, more power, and many other benefits.
Okay, thank you. Thank you for your sharing. Interesting, and I agree with you.
Yep.
In Vietnam, the same. It should, when you mention about the jurisdiction for the dispute settlement, we should select the arbitration or the court. We should not provide the arbitration and the court at the same time because you create a conflict
Right.
Itself. So it's very difficult for the arbitration and even the court to consider to receive the lawsuit when you file the case application to the court.
Right. And I mean, in those types of situations, how do they resolve that conflict? What's your experience there?
From the conflict, if you don't have any mention about the jurisdiction for the dispute settlement, the court obviously has the jurisdiction.
Right.
If you mention about the arbitration, even you also mention the court there, the judge will also refuse. Okay, they will say, okay, you should come to the arbitration first. If both of you disagree not to continue to select the arbitration anymore, you must have the confirmation from both of you. And then you bring the matter to the court will receive to settle for you.
Yep.
Yeah, and vice versa. And if you bring the matter to the arbitration, the arbitrator will also check again with you whether you want the arbitration or you want the court to settle the matter, the dispute for you. And at that time, the arbitration also requests you, okay, if you want the arbitration to settle the dispute for you, you need to have agreement again or to confirm that, okay, both of you now want the arbitration center to have you to settle the dispute.
Yep.
So, and even at that time, because you already have the dispute already, at that time you ask the opposite side about selecting the arbitration or the court, maybe they will not cooperate with you anymore.
Right.
And they create more difficulty for you.
And I suppose that's one of the key takeaways for an arbitration agreement or clause is consent. And it's the parties coming together to agree that they will arbitrate in the future. And often it's one of those things which is left, which what I call the midnight clause. It's left to the last possible second. Let's just put it in. That's dangerous because what happens if you get to an arbitration and it's not in your language? Oops.
Okay. Okay, so very interesting. And we finished the topic of the arbitration clause in the commercial agreement today. And we come to the conclusion of the advice that when you mention about the arbitration, the court litigation, it should only one authority.
One authority. That seems clear.
Yeah, okay. Thank you, Jeremy.
Good. Thank you, Sim. Yep, pleasure.
Okay.